everybody. This is Martin Valko and Nick Chavez doing our weekly wrap up from Chavez and Valko, your key to immigration solutions. We are recording today's show due to inclement weather, and we just want to make sure that if should we lose an internet connection or something happen that we can get through the show. I got my law partner Nick Chavez in our Fort Worth office. I'm here in Dallas office. Nick, how are you doing?
Doing well. We're rolling tape, right? So we're recording, but you can still send a question later. We'll be glad to answer any questions or comments you may have.
Yeah, and please like the posts and follow the Facebook page so you can tune in for notifications. We also have some links to register with our platform and download our app, Lawpilot Guardian, which is just a fantastic way of knowing that somebody out there is got your back, and if you have an emergency or you want to stay in line with the breaking news, you'll get the push notifications with that. So anyways, we have a weekly wrap up. We're just going to run down our agenda. We'll talk about the DACA, the new rule being officially in place and enacted, but it had some issues with it. So Nick will explain it. We'll talk about the executive pardon that President Biden had proposed, and there are some updates that we'd like to get it to you, so you'll know what's going on in the world of immigration. Nick, what's new on the front of the DACA rule? What's going on there?
So DHS announced that that DACA is officially now operating under the regulations. Just if you recall, back in August, they announced that they were going to have these new rules. We were excited about it, but because of litigation, things have stalled. Right now, this announcement doesn't really mean anything. It's like there's no there because things are continuing the same as they did last week or a month ago. That means they're still accepting renewal applications. So if your DACA application's or your DACA status is about to expire, you should definitely think about renewing. And they're still accepting applications for advanced parole. But they still are not approving initial applications. They said that they'll accept it, but we're not going to consider them due to litigation. So it's basically an announcement that we have now officially entered the regulations. This is after October 31st, but we still cannot approve initial applications. So really, there's no there.
Yeah, and so when you read the opinions carefully, from the Fifth Circuit and now kicking it down to the Southern District to Judge Hannon, there's also some fear in the DACA grantees' eyes when they read it, that when you can read into it and think that this could be disassembled, this could be taken apart, and so we just kind of want to allay those fears that if that were to happen, I think that would push our congressional representatives into something more permanent, hopefully some legislation protecting DACA grantees.
Yeah.
What do you know about the? Are there any consequences on the immigration front from this executive pardon that President Biden was talking about?
Yeah. So if you recall, a couple of weeks ago, we mentioned that President Biden was going to make this big announcement. And what happened is that in light of what's going on with the states, decriminalizing marijuana, being more flexible in that front, President Biden, along with that as a backdrop, he also mentioned that a lot of people's lives were being destroyed just for committing something simple crimes such as a possession of marijuana, and also noting that there's disparity between those who are arrested. There are more minorities being arrested for a crime that is really committed by a lot of people. So in light of all that, President Biden said, we're going to go ahead and become more flexible. We're going to relax some of our policies regarding marijuana. And let's be clear, this is also a political statement, right? As we head into the elections next week. But first, what he did, he made an executive order. He said, this is a federal pardon of all federal marijuana possession offenses involving simple marijuana, simple possession, I should say. So that applies to those who have been convicted under federal law of possession of marijuana. And secondly, he urged the governors of all the states to do the same, really just to use their resources wisely. Now, the number of people who are affected by this announcement is not that big. It's a great step forward into decriminalizing marijuana federally, but comparatively speaking, it's just a small number. We're talking about 6,500 people. That's how many people are going to be affected. And why is that? Because most simple possession crimes are treated under are processed under state and local laws, and we're seeing a lot of states go the way of decriminalization. So naturally, you're going to see lower conviction rates. It is just not something that the district attorneys and police departments are too focused on. There are other serious offenses. So you have that. And thirdly, what happened here is that Biden also said that it's about time that the government starts to review the way that it classifies marijuana under the federal law. And specifically, we're talking about the federal the Controlled Substance Act, and they have 4 lists. So they call it schedules. And up at the highest is Schedule 1, and these are drugs that are like really bad. These are drugs like heroin, cocaine, drugs that have no medical use. Well, marijuana is listed on in that schedule, and it's listed higher than the Schedule 2 drugs, which they're also serious. And these drugs include fentanyl, meth. And so that doesn't make sense. Marijuana is on the higher scale with respect to the seriousness of this. But yeah, that's what the announcement was about.
Yeah, and we touched on it last time. I mean, you have foreign nationals that are in their home countries where they have a prescription from the doctor, and they think like, well, the doctor prescribed this to me, and this is a very light, prescription medication for medical purposes, and then they are straightforward or they are forthcoming with that information with their doctors. I mean, with their doctors, obviously, but with the panel physician who's testing them, who's applying the medical exam to them, and then they'll find them inadmissible. And they're punished, quote unquote, where they have to stay in their home country for a year. They can't get a visa. They can't come to the U.S. for business, for whatever purposes they're coming in. So that's difficult when you are not just buying it off the street like people used to, but you're going to doctors who's prescribing you a very low dosage of something medically prescribed. So
but this I'm sorry. I was going to say that this pardon, though, is just it only includes citizens and lawful permanent residents, and we're not there yet. When we heard these news, I was thinking about those clients, the clients that are in Ciudad Juarez, and they might have used it for medical purposes. We're not there at that point where it's going to waive those types of offenses. It's just simply a pardon that applies to a small section of the population, residents only. That means that this executive pardon is not going to apply to asylees, refugees, non-immigrants, undocumented immigrants who are right now currently facing criminal charges. It does not help them at this moment. It's only if you're a lawful permanent resident. So what we really need is for them to remove marijuana off that federal schedule. So when they're reviewing the lists, for it to really have an impact on immigration, we need them to remove them from being considered under those lists, not being considered as a controlled substance, if you will. And I think that would make the biggest impact.
Okay, moving on. So there's good news out of the Ninth Circuit. We've seen that in the past where the Department of State does not really give you much when they deny an
Hmm.
immigrant visa for somebody, for a spouse that's married to a U.S. citizen petitioner. What is this case? This is Munoz versus State Department. What's that? What's this case
Yeah, so
about?
this is a Ninth Circuit case, a case out of rising out of California. So what happens in some of these cases when we deal with applicants who are applying for a visa outside an immigrant visa through a family member? We have many clients who, for example, are waiting for their interview notices in Ciudad Juarez. When they're in front of the consular officer, the consular officer will have the final say in terms of whether or not this person is eligible or not. This person who had applied for a visa had lived here, and he was filing an application based on a petition that was approved through his U.S. citizen wife. So he had lived here. He went outside for his interview, and they told him, nope. We just think that you're up to no good. I mean, they call it unlawful. We think that you're going to commit unlawful acts or unlawful activity, but they didn't tell him no. And this is sort of the practice at the consulate. They'll check off that box that says, we're going to deny you because of this general ineligibility or disqualification, but they won't give you like specific reasons, in which are so important. And what this court decision does, it says, well, no, there is, number one, there's a U.S. citizen involved. This is the petitioner. They have rights. That petitioner is wanting somebody to come in the United States. That's the right they have, to have a family reunited here. And so to not tell that person the reason why you're refusing his or her spouse of entering the United States is just bonkers. It's how doesn't make sense. So it opened the door a bit for those types of cases. We don't know how expansive it's going to get. We don't know if it's going to apply to if it's going to creep into applications for tourist visas, for example, which we would love. We would like to know a specific reason so we can address it. But usually in these types of cases, they'll check off a general reason, a general disqualification, but they will leave out a specific reason, and you're left kind of in the dark of knowing why. I mean, is there something that they could do?
Yeah.
So it's a good case.
Yeah. So the consular officers, they hide behind. I mean, this is basically that there's this concept of consular non-reviewability, which means that you really can't do much. You can't really contest the decision, and it kind of breaks on two grounds. Was it denial based on question of facts? Was it a denial based on question of law? And so if it's denial based on question of facts, and here I'm just kind of touching more on the non-immigrant visas, for example, then there's really much, like you said, general ground for denial. You haven't been able to prove that you will return, that you did not have immigrant intent or preconceived intent. And that's pretty much the end of the road for the applicants. Now, then there is a denial based on question of law. And if you, or if we as attorneys are able to contest it and prove it, typically we go back to the post and see, hey, this is not really about facts. You had misapplied the law. You've created the new law, like it happened to us in some cases where the consular officer just made a decision, and they've combined a title of a section of the Immigration Nationality Act with working unlawfully, and they've made the person inadmissible for 99 years. That's like, I still have that denial sheet, which we're just looking at it, just grabbing our heads. Like they just made inadmissibility ground just based on thin air. So there is you can go to them, and sometimes, like in my case, we've resolved it after a little time, or then you go to the legal net, which is their kind of an appellate body. Or you can go to the federal district court and sue and litigate against the Department of State and see if you're successful there. Again, very little chances, generally speaking, but that's what they hide behind. All right, moving on. So there was some update from USCIS about naturalization applicants with disabilities. What is that about?
Well, this is good very good development. When you apply for naturalization, there is a requirement that the person pass a naturalization exam, which, by the way, a lot of Native Americans can't pass, but it's a simple examination. And there are some clients who have disabilities. Just like any other exam, right? You're in school, you have to study. Well, this disability, if you have a disability that prevents you from absorbing information, from studying, from remembering things and recalling things so you can pass the test, then under the law, you're allowed to apply for what's called a waiver. It's called N648. And it's a medical certification where you are telling the government, look, I want to apply for my citizenship, but this requirement about me taking a test, I don't think I could accomplish that because I have this disability, right? And so that is the process. You file this certification, you send it out with your naturalization application, and it's up to the officer to decide whether or not that certification is valid or not. Well, what happened is during the Trump era, they added some more questions. And I noticed that on the N648, which is signed by the doctor has to certify that you have a certain disability that prevents you from learning or speaking or writing, just basically meeting the requirements of citizenship. Well, anyways, they made it tough. They were adding some additional requirements for the doctors to confirm. They were asking questions as well to the applicant. How this disability affects everyday life, work and just your daily routine, right? It was talking about, it was asking specific information as to when was the diagnosis made and how severe is the disability. So if you have dementia, they want to know how severe your dementia is. And they're also wanting to know if you had this pre-existing relationship. Wow, so now you have your doctor, your physician who you see regularly. Now he's certifying this. So, it was making it more difficult for doctors to fill out those forms, certainly for applicants to fill out those forms. And what this update does is it simplifies it. It gets rid of those extra questions. It makes it more easier for you to reach out to your doctor and for your doctor to review the form and say, yeah, this is what it is. As opposed to asking a bunch of questions that are irrelevant, and saying the wrong thing could lead to a denial of your naturalization. So it's very positive.
So these extra hurdles, as I would call them, were put in place, I want to say 10, 15 years ago. If you recall, there was a spike in use of the 648s with the naturalization applications with disabilities, which there was some misuse. I guess that was the allegation of misuse, that people were just kind of going around the system. They didn't want to study, so they just went to the doctor, and it was fairly easy to fill out and submit. So then they kind of caught up to like, okay, we're going to make it tougher, right? So it seems like they're pulling back a little bit and getting back to that, but there's still some legitimate reasons left in place, right? So there's not going to be that easy for somebody to just go to a doctor and just have it done. Of course,
yeah. So it's a balance. So you're right. It's a middle of the approach. We're going to be fair, or we're not going to ask too many questions that are just extraneous. We're just going to be fair, but at the same time, it's information that could be verified. So they're trying to strike a balance here.
Okay. All right. And so just kind of moving on to the last item, basically just kind of a quick updates, what we've seen in the last couple of weeks. There is a good news for Ethiopia and nationals and citizens of Ethiopia. The temporary protected status was announced, the designation by the DHS. So it applies to anybody who was in the U.S. on October 20th of 2022 will be eligible for temporary protected status. With that, you will apply for work permit, and you'll have the designation last for 18 months, just like we have with the other countries that are currently designated. Number two, we have USCIS implementing a new process for Venezuelans. So typically people that really don't have the ability to just get a visa and get here, get to the U.S., they are able to apply for a parole, which is will last for up to 2 years. They can do it online, so they basically do it ahead of time. And there are about 3 or 4 requirements. You have to have a supporter in the United States who would financially provide for you, and plus any other support. You're going to have to undergo some security clearance, meet some eligibility criteria, and then the exercise warrants a favorable discretion, so that you should get it. And that's kind of, there was a kind of bunching up of applicants at the border, and so they just wanted to clean it up, and they just moved it online so you can get pre-screened and then get that parole ahead of time, so then you can just get on the plane or come to the U.S. The third thing on the list was the USCIS. With the delay in processing of certain benefit applications and petitions, one of those are renewal of people's green cards when they apply for I-90, which is typically renewing somebody's green card if they lose it, if it's expired. And so now once they do that and they get a receipt, there's an extension for 24 months. So they can travel with that. They can keep being employed in certain situations. So that's also good development. Now, it's great that they do that, because before you'd have to get an InfoPass appointment and get a stamp in your passport. And so that's no longer necessary, but at the same time, it still kind of displays the delays that we're facing in our practice. Another thing that was done was extending employment authorization documents, the work permits. So there's expedited processing available for healthcare and childcare workers. So what's already in the place is if you're basically extending or renewing it, and now they've applied it to the new applications. If the application has been pending, beyond 90 days, the applicants are then eligible for expedited processing. Another good development was extending the flexibilities in responding to certain requests from USCIS. We call it the COVID-19 related flexibilities. And that's basically when the government comes back to you and they want additional evidence, or they send you a notice that they don't think this is going to fly, that there's a notice of intent to revoke or deny. Generally, you have a set deadline, but now they're adding 60 days to the deadline, as long as your application was filed between March 1st of 2020, when the COVID-19 flexibility started, all up to January 24th of 2023. And then they're also adding 90 days to the naturalization application's denial. So if you want to appeal it, or the motion to reopen or appeals of certain USCIS decisions, then you get 90 days if the decision date was between November 1st of 2021 and January 24th, 2023, which is the same date, corresponds to the other 60-day addition. And then also there was an extension to there was a temporary waiver of the 60-day rule of the civil surgeon, which is the medical exam, the Form I-693, that, for example, the applicants for adjustment of status when they apply for a green card. So that basically said that the medical exam had to be signed by the doctor within 60 days of filing that application, of asking for that benefit. And so that has been extended up to March 31st, 2023. So that 60-day rule is suspended. So that's basically kind of a quick update on these recent developments. It's Friday. We wanted to get back to you. We haven't been with you in a couple of weeks. We just wanted to keep you updated and let you know that we're here. We'd love to hear from you. So feel free to send us your emails as you do, or just comment on the video with any questions. And if we can respond, we will. Keep in mind that sometimes it's really difficult to respond to some questions because it has some personal information, or it requires some further analysis or fact finding, so that we may have to schedule you for a consultation. But it's good to be back with you. Nick was with you on Wednesday during our Spanish speaking program, talking about the pardon by President Biden, I believe. So just kind of stay tuned for our lineup. and reach out to us. Again, help us. I don't know where we are now in terms of YouTube. I think we may be close to 2,000 subscribers on
we're
YouTube.
Close to 2,000, yeah. We're
All
close
right,
to 2,000.
so just help us get over that hump.
Well, the goal is the goal is 10,000. I think that's what we're aiming for at least next year. We're going to aim for 10,000.
Hopefully that will happen. And again, let me see if I can open up my app here. And this is the Lawpilot Guardian. So very, very, very helpful, useful. Our clients and prospective clients call it my attorney in my pocket. So if there's an emergency, when you activate the button, we know where you are. We can hear your conversation, which gets uploaded to the cloud for our review. So if there's anything that we need to do, we would reach out to you to make sure you're okay, to your family. We can take steps. It had pre-recorded statements, so you can play a message to law enforcement. Obviously, it's loaded with information such as know your rights. And then if you have it and you want to schedule a consultation with Mr. Nick or myself or any other attorneys, you can do it from your app. So anyways, that is all for me. Love being back with you. And I don't know, Nick, any parting words?
I know you said it all. And I think that the last thing is that a lot of these things that we're talking about involve political action. So if you do not have citizenship, get involved. Talk to your congressman. If you know somebody, drag that person to the voting polls and vote. Out. That's my final word.
Out. All right. Well, everybody have a good rest of the week, great weekend, and we'll see you here next week. Take care. Bye-bye.
Bye-bye.